Hello, everyone. I am Modirzadeh. I am the founding director of the program on international law and armed conflict here at Harvard Law School. And I am really thrilled to welcome you all to this PLAC book event for a book that I was much anticipating and that we will be discussing today. Dr. Rebecca Sutton's book, The Humanitarian Civilian, How the Idea of Distinction Circulates Within and Beyond International Humanitarian Law. I'll just say a few administrative items, then I will introduce Professor Sutton, and then we will turn to her for her remarks and open up for questions. So first, I want to note to everyone that this event is being recorded. The recording will be made available on the PLAC website, and so you are so informed. Second, we will save most of our time for question and answer from the audience. So Dr. Sutton will give about 30 minutes of remarks, and then I will try to contain myself from asking all the questions and open up to the audience. This is in webinar format, so if you have questions or comments, please feel free to use the Q&A function at the bottom of your screens. I will be able to see those questions and I can pose those either anonymously if you so prefer, or I can name the questioners. You can also use the raise hand function to indicate if you have a question, and we will turn to you to ask your question directly to Dr. Sutton. So let me take a moment to introduce our guest, and then we will turn the floor over to Rebecca. Rebecca Sutton is a Leverhulme Trust Early Career Fellow at the University of Edinburgh Law School, where she teaches conflict resolution subjects and researches the role of emotions in international humanitarian law. Her scholarship appears in leading journals such as the Leiden Journal of International Law and African Affairs. Her first book, what we're discussing here today, The Humanitarian Civilian, was published by Oxford University Press just this year. Rebecca has previously been a visiting fellow at the Oxford Institute for Ethics, Law, and Armed Conflict, an SSHRC postdoctoral researcher at McGill University, and a Kathleen Fitzpatrick Fellow at Melbourne Law School. She holds a PhD in international law from the London School of Economics, a JD from the University of Toronto, and a master's in violence, conflict, and development from SOAS at the University of London. Rebecca is a licensed barrister and solicitor in Canada, having been called to the Ontario Bar in 2014. Crucially, I think for our discussion today, Rebecca spent a decade working for humanitarian and human rights organizations and has worked or conducted research in Darfur, Sudan, South Sudan, Ghana, South Africa, Cox's Bazar, Bangladesh, Indonesia, India, and the Central African Republic. We are really thrilled to have her. And Rebecca, I'll give you the floor now to start your presentation. Welcome.
Thank you so much, Naz. And let me just begin by thanking Naz and Dustin and Heather as well for the invite and for helping prepare today's event. And I have to say, I'm just really delighted to be in conversation with people from PLAC, because I've always been a huge fan of the program. And I think it's one of the most exciting sites for IHL scholarship and practice right now. So I'm really excited to be with you today. And also just a special thanks to everyone for joining us after the clocks have gone back. So if you're in the UK, you might be sitting in the dark like me right now. So thanks for being with us. And so what I'll do is I'll jump right in. I'm going to share my screen. I have some slides that should take us about 30 minutes, well, 30 minutes max. And I'll just get confirmation from Naz that you can see the screen okay? Perfect. Okay, so let me just set my own timer so I stay disciplined here. All right, so this is a brief sort of whistle-stop tour of the book, and I'm going to assume that nobody here has read the book or is familiar with the contents. So I'll really start from the bottom of things, and it will be a little bit descriptive just to give a sense of the structure of the book and the story behind it, but then I'll try to dive right into the main arguments and the claims at the center of the book. And I really introduce these as sort of teasers for discussion. So the idea being that in Q&A, hopefully we can go a little bit deeper. So let me just say something first about the book. So this book began life as a doctoral project at the London School of Economics. And when I finished the PhD, I really felt that I wanted to tell the story in a different way. So it was kind of only once I put the whole thing together that I was able to see my way through to a new narrative. And that's what we find in the book. And so in the PhD, like any good graduate student, I was, showing my legal chops. So I front loaded everything on the Geneva Conventions and so on. But in the book, I actually tell the story backwards, and I start in South Sudan and we move from the bottom up. So we go from South Sudan to civil military trainings and on to the most normative realm, to Geneva and The Hague. So I'll say a bit more about that. Now, I want to start with the field of practice because this is where the initial puzzle came from. And so when I was based in Darfur from 2009 to 2011, I was country director for a small child protection NGO called War Child Canada. And what I noticed when I participated in high-level conversations amongst members of the humanitarian community is that we were often very concerned about this thing we call distinction. And so we would talk about our need to be distinct from the UN mission or to be distinct from other kinds of actors sharing the operational space. And we would have heated debates about things like traveling in armed convoys or doing human rights work or engaging in long-term development. And most of the time, whatever answer we arrived at, we would frame it in terms of distinction. And something that later became interesting to me as I trained as a lawyer after my time in the field is that this distinction that we were talking about, sometimes it was a civilian combatant distinction, but other times it could be, for example, a humanitarian military distinction, or even a distinction amongst different kinds of humanitarians. So the more I learned about the IHL targeting rule as a lawyer, the more I began to think, I'm not really understanding how this legal rule governs the intricate practices that I not only observed, but also participated in and shaped on the ground. So I knew I had a puzzle to solve, and this is what I set out to do with the PhD. And one thing I'll add is that when I started, I thought that this would be a story about the law in the books versus the law on the ground. But I had this serendipitous chance to become a trainer at civil military trainings in West Africa and in Europe. And what I found at these trainings was that there was this middle realm, which in the book I call the pedagogical realm. And this was a space that was inflected a little bit with a normative angle, but it was a place where distinction was being taught and learned and brought into question. So I knew that instead of talking about IHL in action versus IHL in the books, I actually had a 3-part story, and this middle training realm was part of it. So that's the problem from practice. Now, let me say something very briefly. I know many in the room will be familiar with the principle of distinction, but something I want to draw attention to is if we consider the principle as codified in the first additional protocol in Article 48, what we find is this idea of a bright line binary distinction. So to be a bit simplistic about it, on one side, we have combatants and military objectives, and they will be legitimate targets in an armed conflict. On the other side, we have protected civilians and civilian objects, and this is where we would find most of the time humanitarians. And the idea is that this rule is alternative and exhaustive. So you have to fall into one of the categories. And if you're not in one, you're in the other. But we know, of course, that even within the Geneva Conventions and in IHL rules proper, that sometimes this line can be less bright than it might appear. So if we think of the concept of direct participation in hostilities, or DPH, we have this moment where civilians who would otherwise be protected from intentional targeting can be legally targeted for such a time as they participate. So already the rule is in trouble, in a sense, I want to argue. And what I try to do in the book is I build on arguments that scholars have made about the negative definition of the civilian. So scholars such as Crawford and Dinstein have pointed out that IHL's definition of the civilian is negative. So the civilian is what's left after the combatant. And I agree that that's true, and it does present us with some problems. So IHL doesn't tell us what civilians look like, for example. But I actually think the more fundamental problem, and this is really what we come up against when we think of the world of practice and the world of perception is that the principle of distinction, like so many other rules of international law, rests on ambiguity and indeterminacy and uncertainty. So that's the point I really want to make in the book. And for my purposes, why this matters is I find that the fuzziness and the ambiguity of distinction continues in IHL's treatment of the humanitarian actor and continues again in the legal relationship between humanitarians and civilians. And why that matters is I argue that it allows IHL to set up some humanitarians as the object of special protection and privileges without framing this as a carve out from the civilian category. So the law can assert that the humanitarian is maybe a special kind of civilian, but this leaves the civilian category intact. And my project aims to show that as a matter of practice and perception, this is not the case on the ground. So when we think of the principle of distinction, we think of targeting, a narrow rule designed to govern targeting in the conduct of hostilities. And this might be the sort of paradigmatic image. So you have someone looking through a site, trying to discern whether the conflict actor they see is civilian or combatant, whether they're a legitimate target. What I wanted to do in my project is turn our gaze to a different set of actors. So I wanted to take us to the land of intervening actors who I had been part of this landscape of actors in conflict settings. And primarily I wanted to talk about humanitarians. So by humanitarian actors, I mean ICRC and Red Cross family, as well as UN humanitarian agencies and NGOs. And I wanted to say something about how these actors distinguish themselves or try to assert their civilian status in conflict settings. And the problem I immediately came up against is that these actors cannot distinguish themselves, so to speak, in isolation. All of this must be worked out in relationship with others who share the operational space. And I knew from my own practice experience that two of the main sets of international actors that posed a so-called threat to distinction would be peacekeepers and soldiers or military actors. And so I expanded the study to try to take a look at the perspectives of humanitarians and how they think they're trying to keep away from or be distinct from others. But I also bring in the perspectives and worldviews of the soldiers and the peacekeepers. And one interesting finding, and not to preempt the findings of the book, but even if we look at these pictures, you might notice that some of the actors, for example, the peacekeeper in the upper right-hand corner, this person might well be categorized as civilian in international law. So they might sometimes be carrying weapons and look quite militarized or combatant-like. But in this picture in South Sudan, a peacekeeper doing a weapons search by default will have civilian status. And so the attempt by humanitarian actors to be distinct from this peacekeeper, we get a sense here that distinction is circulating in civilian-civilian relations where it should not. So that's just a teaser of the kinds of findings that are going to come out here. And I won't go into the methodology of the project today, but to give you a sense of where my claims are coming from, I did field research in 2015 and 2016. So to build on my own practice experience, I went back as an academic researcher, and this included South Sudan, and then civil military trainings in Italy, Germany, and Sweden. And the one thing I should say about the trainings is I chose trainings where military practitioners were being trained for how to interact with civilians in the operational space. So at all of these trainings, soldiers who would be deployed with NATO or another international organization, they were learning how to interact with aid workers and other civilians. And that's precisely the dynamics I wanted to get at from the non-humanitarian side. So if a humanitarian actor in a place like Central African Republic is trying not to park their vehicle near a UN peacekeeper, I want to talk to the UN peacekeeper to see how they experience these practices and what they make of those kinds of dynamics. All right, so that's the big sort of overview of the book, and it's a bit extensive because I need to give a basis for the arguments I'm about to make. And I'll spend the rest of my time focusing on those claims. So first, I'm going to say something about the everyday life of IHL. And this is one of the first arguments advanced in the book. Now, something that I noticed, I often do work that we could categorize as socio-legal. And I think there's two reasons why a socio-legal approach to IHL is valuable for this stage that we're at in IHL's development. So socio-legal approaches, such as thinking about law in everyday life, and I'm thinking here of Sarat and Karen's, for example, the book that you can see in the slide. So in the socio-legal approach, we would think about law's instrumental aspects. So we could think here of how aid workers deploy law, how they try to avoid it, how they change it, and so on. And in this stance, we're thinking of law as a tool or an instrument, but that doesn't give us the whole picture. There's also law's constitutive role and the way in which law constitutes these actors as legal subjects. So what I wanted to know is, even in South Sudan, if humanitarians and others are not invoking IHL on a daily basis, do they self-conceptualize as civilians? And does their understanding of that legal status shape how they organize their affairs, their self-perceptions, and their relationships with others? And I show in the book that it certainly does. And to zoom out for a moment, I had originally come from the field of development studies, and that's where I began before I trained as a lawyer. And what I noticed is that when international lawyers would turn their mind to humanitarianism, they would often tend to take a more normative or doctrinal approach. And I think there's value in that, and we still need that work. For example, there's a lot left to be said on things like cross-border humanitarian aid delivery, or for example, in Naz's work on counterterrorism and humanitarian aid, right? So these kinds of doctrinal conundrums are still out there in the world, and there's a place for legal scholars and lawyers to engage with them. But what I wanted to do is complement and add to that work by showing what kinds of things we might uncover if we took a more critical and socio-legal approach. So I see it as a complementary and a sort of add-on to the more doctrinal work. So that's really the overview of the everyday life aspect. And let me just say something about legal pluralism. So in this book, I am making a deeper point about legal pluralism and about what kinds of actors might be shaping international law. And I wanted to focus on lower level and frontline individuals to get us thinking about more unusual spaces and places where these unconventional actors are doing things with law. But I want to be clear that I'm not claiming that these people are shaping law in the positive sense, in the terms of making international treaties, though some of them actually do. But that's not the claim. The claim is more that these people are producing distinction through their everyday practices and interactions. And these practices, including at the trainings in the pedagogical realm, these need to be sites that we think about when we think about how IHL is produced and reproduced. And so that's the focus on the everyday, that the book tries to say something about that. And then we have the perpetual disruption of distinction, I call it. So something I want to say here is that I was very intentional at the beginning of the study that this is not a project about compliance. And it could be, so you could definitely take the same set of actors and the same problem and do a valuable compliance study. But there were two reasons for which I wanted to stay away from that in this case. So first of all, I felt that it would obscure significant aspects of actual practice. So if I study whether humanitarians comply with IHL, I'm assuming that the civilian combatant distinction is in fact the most significant distinction in practice. But my study actually shows that sometimes, as a matter of practice and perception, civilian-civilian distinctions can be more important. And I would have missed that entirely in a compliance study. The second thing is, if I was focusing on compliance, I would have treated all of the practices, and like a huge part of the book is distinction practices that do not map onto the targeting rule, but they're distinction practices nonetheless. I would have missed all that because I would have deemed it to be irrelevant or extra legal. And I think the problem with that is I would have treated the principle of distinction as both valuable and stable. And a lot of the scholarship and increasing historical work and archival work on distinction suggests otherwise. So I needed to sort of step away from that compliance paradigm to see what kinds of things we might uncover. And that's why a huge theme of this work for me was ethical discomfort, because as you'll see, I end up introducing names for lesser and greater civilians, which is, if ever there was an ethically fraught task, I think this is probably one of them. And so what I try to show is that distinction is messy everywhere. So it's messy in South Sudan when actors talk about what kind of t-shirts to wear and who they can be seen having coffee with. And it's also messy in Sweden where soldiers do virtual reality trainings and decide how to behave when they encounter NGOs. And crucially, it's also messy when we get to Geneva and The Hague, and we get to the Geneva Conventions and the additional protocols and the practices of the international courts. Even there, we don't find a bright line rule that's stable. But what I find, and this is really the crucial finding of the book that sounds incredibly simple, but I think it really is the core finding, and it's that so many people in so many different places for so many different reasons are reaching for this bright line distinction, even as it eludes their grasp. So there's something intoxicating and compelling. And many of us, including myself, we want to live in a world in which a bright line distinction exists. And I think there are two reasons for which the bright line stays in circulation. So first of all, the principle of distinction has always been tied to IHL's functioning as a body of law. So there's this idea that if distinction falls apart, the whole IHL project falls apart. So those are very high stakes in terms of one legal rule kind of propping up an entire body. But then we can also think, and this is something Amanda Alexander has shown in her work brilliantly, that today's protections of the civilian, including the principle of distinction, tend to be presented as a culmination of a historical progress that's moved towards greater and greater protection. And so if this is the point we've arrived at with the greatest protections for civilians in history, so to speak, then what does it mean if it's not working, or it's messy, or there's a problem? So I think we have to understand these 2 points to understand why people who know about direct participation in hostilities and who have maybe seen active combat and what goes on in practice will still insist on the bright line distinction. So there are very valid and strong interests maintaining the bright line rule. And my project troubles that the whole way through by just showing this mess and this chaos. And the crucial point to take away from that is that distinction is chaotic, and this is apart from and prior to anything that humanitarians are doing with it. And as I'll show, they definitely are adding to the chaos. So that's the second claim. And now the third, and I'll spend a bit of time on this one. And this is the main original argument at the heart of the book. And it's also the most provocative aspect. So I think it's good to really explain what I'm claiming and what I'm not claiming, because if I just mention it superficially, it can sound quite abhorrent. So I really need to walk through it carefully with you. So here's the argument about the existence of the civilian plus an international practice. So if we put aside for a moment the vision of distinction I shared with you at the beginning of the presentation, so you'll remember that was a bright line rule with the 2 sides, the civilian and the combatant on each side. And what I want to do is just completely shatter that vision and introduce to you a very different and more dynamic vision that I think represents the vision of distinction that humanitarians promulgate in their everyday practice. And I should be clear, they're not often saying this as part of the discourse or saying out loud that we think there are different civilians, but I'm reading this belief into their practices. So to be clear, especially as an academic from an ethical perspective and in terms of reflexivity, it's me who is introducing these special statuses, and I'm giving names or labels. And it's a fraught task because, as we know, IHL already has this tendency to over taxonomize. So it's not like IHL is in need of new categories, right? But I think there's value in this analytical exercise because it can tell us something about how the world of practice might be doing things to this legal category that's so important and treasured. So if we distance ourselves from the bright line and think of this dynamic vision, here's how I think it works. So the way I see it is there are floating signifiers that are just in the air. And these are signifiers of what we might call civilianness and combatantness. So civilianness we would associate with everything when we think of maybe a pure civilian. So this would be innocence, harmlessness, and non-participation in the fight. Combatantness would be the opposite. So complicity, danger, being tainted. And I use this add-on, this ness, so civilianness, combatantness, because what I'm really trying to get at is equality. And the idea is that you could be anyone in a conflict zone. You could be someone who, as a default, would have civilian status or combatant status. And you could draw down these qualities of civilianness depending on how you carry yourself, how you dress, where you are, and who you're seen with, and how you behave. So instead of having these static statuses that everyone claims or is assigned, we have these floating signifiers that might affix to anyone at any moment. And once we understand this, we can think of what I would call the civilianness continuum. What this means is that when international actors confront each other in the operational space, they're not necessarily jostling over who is civilian and who is not civilian. Instead, it's much more subtle. They're jostling over who is more or less civilian. So here, civilianness detaches from the civilian, and everything is a matter of degree and nuance. So it's all basically gray area. Now, and in the book, I spend all of chapter 4 living in that world. So that book just jettisons the idea of a line, and it's all floating signifiers. And I show how this works in South Sudan and at the trainings. But ultimately, I felt that I couldn't leave us in that world. So it's one thing to give this sort of rich ethnographic picture of those practices, but it was really important to me to come back and say something to IHL lawyers about what this means for our category of the civilian and the principle of distinction. And so at the risk of losing some of the dynamism, which I think is a more accurate depiction of practice, I wanted to come back to introduce 3 figures. And these are discrete figures, a sort of triptych, if you will. So on the left-hand side, you can see the civilian plus. And this, I argue, this is the status that humanitarians long for. So the status is somehow, it's entitled to all the same targeting immunity as the others. So the civilian aspect of these 3 figures is all equal. Everyone's immune from targeting under law, but it gives them something more. It's a special signaling of perhaps their virtue, of the dangerous work they do in conflict zones, a bit of extra immunity in a sense. And basically, this is a status that they can use as a cleansing agent. So when they're accused of being a kind of lesser civilian, they can use the plus to shield against that. But they can also use it to sort of drag themselves out of ordinary civilianness by having the plus. So this mere civilian, this is the civilian we would have for everyone if the concept of general civilian protection applied equally to all. So this is a default status that reflects people who have done nothing to attract the plus or the minus. And the civilian minus, this is actually the status that I argue haunts humanitarian practices. So even, and perhaps especially when they're engaged in quintessentially humanitarian tasks, like delivering food aid in a conflict zone, they might be seen as civilian minus because they're feeding, quote unquote, the enemy, right? So even when they're doing by the book humanitarian work that we could say is the purest humanitarian work of all, they might be seen as combatant-like because they're engaged in the fight. And outside of the humanitarian realm, to think of the civilian minus, we only have to think of the idea of direct participation in hostilities. And that's a case where you have someone who's otherwise civilian, but they've done something to detract from that status temporarily. So let me just finish by touching on a really thorny normative question. So as I introduce this special civilian figure, you are probably wondering, is this a good thing? Is this something we want? And what I tried to do in the project is defer that question. So as I began the work, I started to feel the Civilian Plus was a dangerous idea. But I knew if I front loaded that finding, I wouldn't explore the practices in question to their fullest extent because they did just seem to be a bit dangerous. And so I really parked that. And in the book, it comes out in the final chapter. Now I won't end there today because I know that's quite unsatisfying. So let me tell you a plot spoiler, if you will, how I come down on this question. So what I do is I set up an artificial debate. To be clear, this debate is not happening, and I think it should be happening. So on the one hand, we have the help the helpers point of view. And this would be in favor of a special status for humanitarians to incentivize their important work in war. Then against this, we have what I call the against humanitarian exceptionalism view. And here I'm amalgamating work by Larissa Fast and Didier Fassin and others about hierarchies of human lives. And ultimately, it's a close call for me. I think we can disagree on this one, but I come down on the latter side. And my concern is that if we give a special status to humanitarians, will entrench pre-existing inequalities between them and the populations that they seek to serve. So because the general civilian population provides humanitarians with a raison d'etre, I think there's something potentially perverse about setting humanitarians apart from them with the special legal status. And I'll just finish by saying that the stakes are actually much higher than debates about the humanitarian realm, though I think that's important enough to excuse, having public debates on it. But something I want to emphasize is that calls for special civilian figures circulate all the time in connection with other groups. So I've been at events where journalists have shown that they too are longing for a special civilian status, and advocates for children in war have called for them to be special civilians. So the Civilian Plus, this idea I've introduced, I think we can apply it elsewhere to other categories. And the point I want to close with, and here I'm just mentioning this hashtag that circulates on social media, hashtag not a target. And this was originally designed to draw attention to civilian spaces like children's schools and hospitals to say that these are not targets in war. And it's increasingly circulated in connection with aid workers and humanitarian workers. So whenever there's an attack on humanitarian facilities or aid workers, we see hashtag not a target pop up. And a point that I really want to make with this project is everyone is longing to be not a target. All civilians are. And my provocation, my intervention in this field is to say, at what point, if we grant special status to different kinds of civilians, reflecting their different characteristics, at what point do we just erode the entire idea of general civilian protection? So that's the mischief that I want to avert, I think, through this project. And what I'll do is, if you've made it this far, just to conclude, I'm just going to give a discount for the book. So just to read out, this is an author code. So if you're interested in the book, you can use this to get 30% off. And the code is ALAU. That's my timer, THC4, and I can send that to Naz later as well. So I'll stop sharing my slides, and I'm really looking forward to engaging with you all. Thank you for listening.
Wonderful. Thank you so much, Rebecca. I'm going to invite our participants again. Please feel free to use the Q&A if you would like to ask your question anonymously, or you can use the raise hand function and I will call on people. I'm going to start with a few questions, if you don't mind. Really a wonderful presentation. And I have lots of questions about your approach and about sort of what you would, if your approach was to be followed in other areas of IHL, what would be kind of your dream list of not just socio-legal, but I think incredibly situated and morally situated, but also literally situated research work on IHL. It's so refreshing to read your analysis, both for the very specific questions you're asking, but I think more broadly in terms of what other aspects of IHL we could imagine having the kind of treatment that you've given, the careful, thoughtful, and really, I think, open-minded approach that you've taken to the questions that you're asking. But I'll hold off on that and two more specific questions. The first is on this the stickiness of the fiction about distinction. So you talk about this throughout the book, and you mention Amanda Alexander's reflection that perhaps it is the very fiction of the distinction that gives it such life, and that makes it so necessary for IHL work. But I'm wondering, specifically in the humanitarian context and in the training context, where in my experience, there is this sense of a kind of realist, very cynical approach to law sometimes, right? It's very different from teaching law students or from going to a legal conference. These are often audiences that are already primed to be very cynical about the role of law. Why do you think in those spaces, so these pedagogical moments that you so beautifully illustrate in the book, why hasn't the messiness that you observe, that must be clear to so many of those audiences, been recognized and more clearly acknowledged in humanitarian practice? I'd love to hear your thoughts on that. And just a second question, if I may. I'm interested in how you think your approach allowed you to get beyond, I think, where critical analyses of IHL often stop, which is to reflect on the constitutive role of IHL in violence, or the constitutive role of the law in the very tragedies that we see in the field, but rather to move to this question of actually who's making the law and what does it look like in an everyday context. And I guess I'd love to invite you to say a bit about your choices in framing the project. And it's sort of not, it strikes me that you don't spend a huge amount of time explaining to us what you're not doing in the context of critical legal studies or critical approaches to international law. And I'd love to hear whether that was a choice and why, in terms of the audience that you're trying to reach. Over to you.
Thank you so much for these rich questions, Naz. And if I can just touch on this sort of pre-question you asked, I would just say, I would love to apply or see this approach applied to any IHL rule that is taken for granted or like very closely held and cherished. So anything that seems beyond reproach, something like perfidy, I think would be really interesting, or ruses, and and why certain things are permitted. And there's something about the practice-based approach that I think lets us just stave off briefly the normative aspect. And if we front load that, we lose a lot of the practice understanding. So I think it's especially useful for rules that we don't want to cease to exist. We want to live in the world where those rules are upheld. So it's dangerous to challenge them. I think the approach works there. But let me start with your second question. So I would say my approach has changed. So when I was a doctoral student, and Naz, you met me in like the fragile early years, you've probably seen the change. So when I used to present, I think like if there was a 30-minute presentation, 15 minutes would be me saying, well, okay, so it's not this, and it's not this, and it's not, and everything, because I came to academia late as someone who trained first as a lawyer and first was an aid worker. And I was learning about the debates as I went. So it was like, as I was doing field research and as I was writing the doctorate, for the first time, I was learning about TWAIL and critical approaches to international law and legal theory. So I think initially everything I did was about what I was not doing, and a lot of throat clearing. And it's only once I finished the project and got to rewrite it, like I spent a full 2 years rewriting it into the book, that I could see what it was. And so I think it's once I rewrote it from the bottom up and I moved from South Sudan up, I started to own that like this is an entire approach that's coherent in and of itself. But I have been thinking a lot about the critical legal studies aspect. And there was recently a really interesting podcast with Dina Suvala. I'm sorry if I pronounced her name wrong, but she talked about this question of whether critical legal scholars are supposed to offer answers or solve problems, or whether the destruction or the critique in itself is, sufficient. And I think I struggled with that in this project because I knew if I had a policy answer that the tail would wag the dog. of the project. And so I always tried to delay using grounded practice as my sort of excuse to sort of forestall or stave off the normative finding there. But for me, it was quite existential, because some of the things, as soon as I started writing about the civilian minus, I thought, like, what does it mean to be a person who's giving words to people we could target with violence and war, and whose lives we could take? And if this project doesn't happen, it suggests that, well, maybe I'm the one breaking up the civilian category, because I'm making the project happen and I'm putting words there. So I found that existentially just like incredibly fraught. But as to the stickiness of distinction, I'll just say I found out more about this in my more recent work on emotions. And engaging with your work on passion and IHL as well has been really fruitful. And what I've found, I've been focusing more on frontline humanitarian negotiation. So I chose to focus on that because I wanted to understand, in this more specific field of practice where international law actually has a lot to say about access, for example, what are humanitarians doing with IHL? And I find actually not a lot. There's not a lot of explicit law talk, as Stephen Ratner would say. But in my early interviews with practitioners, I found that most people have the impression that the military and soldiers are much more flexible with IHL and open to nuance, whereas they see humanitarians generally as the hardliners. And I think this reflects what I've often seen. And I think part of it is that if you take an organization like the ICRC and their role as a sort of guardian of IHL, they feel that responsibility to defend the concepts and to sort of put out the hard line. And so I think that's why we see that. And I think that's why, for me, communicating this project to those types of actors is very delicate, because this work can sound very threatening to the humanitarian project. So I think that's what's at stake there, and why some people might be seen as more hardline, because they feel they have to be, I think.
Yeah, really interesting. I'm going to attempt to authorize one of our attendees to talk. Yanis Kalpouzos, I'm going to invite you to use your microphone to ask your question directly.
Hello, can you hear me?
Hi, Yanis, yes.
Hi, thank you very much. And and thank you for this wonderful Prezi presentation. I've been really wondering who can actually use Prezi really well, and I got the answer today on the book. And I'm halfway through the book, and I think one of the most fascinating and useful and interesting aspects of it is how you really show and engage with the sort of situated nature of the application and development of this messiness, and the way that this distinction that you recognize, right, appears in the context of the reaction to the facts on the ground in many cases. But I wanted to ask, though, to what extent also, so we know that the category of the civilian and the threats and the erosion of the category of the civilian, especially in non-international armed conflicts or in armed conflicts that have a non-state armed group or guerrilla element, is also sometimes due to certain sort of conceptual and practical evolutions related to, for example, the war on terror, the notion of new wars back from the 90s, and the erosion of the line between war and crime, or relatedly also the evolution of the mandates or the practices of certain peacekeeping missions. And these are threats, or these are factors in the erosion of the category of civilian that, you know, might be specific in particular situations, but are also trends that are global in some ways, right? So I guess my question is whether those that are explicitly or implicitly arguing for a civilian class notion, to what extent are they sometimes consciously and deliberately also responding to these global tendencies and threats to the category of civilian, in which case, you know, I guess your argument would be that it is an understandable response on that global, but it might backfire, right? Or it might be problematic in some way.
Oh, thank you, Giannis. That's brilliant. And that's really clear. So I think I understand the question. So let me get right into it. So actually, you're really touching on something crucial here, which is that the reason I started the project was actually I was interested in humanitarian advocacy, and contacts of mine in the humanitarian community said, could you study the way that comprehensive missions, whether it's NATO comprehensive missions or integrated peacekeeping missions, are eroding the distinction between humanitarians and other international actors? And they wanted me to show, or for anyone to show empirically, that these trends towards integrated missions or comprehensive approaches were leading to increased targeting of humanitarians. So the humanitarian community was already advocating on that point, but they wanted like robust scholarship to substantiate their claims, so that they would then have something they could bring to these other actors and say, you need to respect our boundaries in conflict settings because you are making us less safe by encroaching upon us. And so that's how I saw the problem. And I experienced that myself from the humanitarian side, very much the feeling of encroachment and of having to be the one who takes responsibility for the distinction, because these other actors are more invested in being seen with you and being affiliated with you and having a bit of humanitarianness rub off on their missions. And so that's how I saw this problem. And I think this is a problem out in the world, and we could describe it this way. But I didn't know that that's not what a PhD is. And so when I started the PhD and I got to the London School of Economics, they were like, you can't do an advocacy project. Like, you can't come in with the answer and then go find, evidence about the targeting. And I was like, oh, I didn't know that. And so I really walked it back. But there are still many stakeholders in the humanitarian community craving that kind of evidence. And, we have some evidence about it. And so what I did is, and this is why I went to study trainings, I first ended up at the trainings by accident because I stepped in for someone in West Africa. And when I was at the training, I was teaching military actors how to interact with humanitarians. And I was a trainer myself, so I was wearing that hat. And I thought, what am I doing? Because these comprehensive missions, the message they're sending to military and peacekeeping actors is, let's dismantle all the boundaries. Let's break down the walls. We have to work together. Like, working together is like the song or the mantra, right? We have to work together because we all want peace. So only if all these different interveners could get on the same page and share information and team up, that's the only way we can stop these wars and help civilians. So that's the narrative there. And I thought, isn't that like the sharp end of a problem for distinction? Because distinction would have everyone stay in their little spheres. And what I found that's really interesting about the pedagogical realm is that in Geneva and The Hague, in the most normative intellectual space, and in the classroom settings of the trainings, it seems possible to have it all. So it seems like you could uphold distinction and have comprehensive missions where people work together, that there would be a way of balancing those competing concerns. But as soon as we start edging towards practice, and this starts in the trainings when we do simulations and role plays, including virtual reality, then you start to see it's impossible. It's impossible to have people think that they need to be seen with humanitarians, teamed up, while humanitarians can be in their separate civilian sphere protected from targeting. So these are real, empirically observable problems, but I still wanted to intervene and say, despite that, this is the kind of problem that makes us want to have a special civilian. Like, if ever there was a time, I look at that and I say, let's give more legal protections to humanitarians. This is a state of affairs that's untenable. But I think it's especially in reaction to those kinds of empirical scenarios that we need to guard against the instinct to give something more, because I argue that it contributes to the very erosion that's the problem in the first place. But thank you so much for the lovely question.
Really wonderful. And I think, Rebecca, you're also touching on, I think, a debate that has long been addressed in kind of the humanitarian policy circles. So we know there's lots of reports and analysis, and I really appreciated the way you talked about and surfaced in an academic setting the way that sort of humanitarians often even question, where do they eat in the cafeteria, right? What's the sort of all-seeing eye approach to how you live your day-to-day life. I remember there were many debates around this after the Canal Hotel bombing and the question of whether or not there had been too much back and forth between the humanitarians and military actors before that strikes. I think it really also allows a scholarly lens on a conversation that has often not been noticed really by those that work on IHL from a legal perspective. Is it okay if I pose a few questions at once and you take notes? Okay, great. So I'm going to read 2 questions from the Q&A, and then if we have time, I'm going to go to Dustin for a question and then back to you to close us out. So the first question I wanted to ask is from Yusuf at Yale Law School. He asks, to the extent there is a civilian plus, is there also a combatant plus and a combatant minus? Would this approach allow us to be more harsh or more empathetic to various combatants? Great question. And the second one is, hi, Dr. Sutton. This relates to the last point you made in your presentation, but from a different angle. Wouldn't granting special status to humanitarian workers also perpetuate existing inequalities between the global North and South, seeing as how humanitarian organizations are often from wealthier nations? It strikes me as problematic for humanitarian workers, many of whom might already enjoy privileges simply by nature of their nationality and/or ethnicity, to be entitled to more protections than the population they purport to serve, and weighs against granting such special status. And now, if we're okay with it, I'm going to turn quickly to Dustin to give us a question as well, and then we'll come back to you. Dustin, go ahead.
Great, thanks very much. So just quickly on, or maybe a short question, which is, at least for me, I'm wondering if you might be able to shed light for current students or maybe even would-be students, so people who might be currently in the humanitarian actors or even security actors or others who are thinking about pursuing the type of deep research and engagement with the topic over what might end up being a long time horizon. Like, what sort of tools and techniques or methods should these folks be thinking about developing in order to produce the type of knowledge and insights that your work has been able to do, given the range of experiences people might have and these encounters they might have with the sort of co-constitutive nature in some way of the observer, the participant, the researcher, the academic, the different hats you've worn during this process?
Great, thanks. Over to you, Rebecca. I'm afraid you are muted.
Whoops. Okay, I was just saying I'll take them in turn, and they deserve much more attention than I will give them here. So Yusuf, first of all, yes, I think there is a combatant plus and a combatant minus. And the sort of greedy scholar in me wanted to like lay out the whole spectrum in the PhD. And then my supervisor, Gary Simpson, was like, stop. So there was kind of an understanding that I had to focus on the civilian side of the equation, but actually how I see it in my own mind is that this expands across the whole spectrum. And when I read about, other foreign fighters or terrorists who are seen as sort of the wrong, unlawful combatants, so to speak, that could be like a combatant minus. And some peacekeepers, say in the Congo with a forced intervention brigade, where they might have combatant status, they could be like combatant plus because they have this sort of supposedly virtuous mission. And so, yes, I think there's a lot we could do. And I'd also be interested in thinking of it outside of armed conflicts, some variation on this when we think of drug wars and urban violence and situations that fall short of armed conflict, where these categories of civilian and combatant aren't doing work and maybe shouldn't be if IHL doesn't apply, but some equivalent in the legal realm. Thank you for that. And then the second question was anonymous, I think. Yeah, that was just what you said was so beautifully put. So I think we need to be worried about all of these things. And something that really came out for me in the project was the issue of race and ethnicity. And I would slightly finesse the question. I think the issue isn't precisely that most humanitarian organizations are from wealthier nations, but what really concerns me is inequality within humanitarian organizations between so-called national or local staff and international staff. So it could be, MSF or Mercy Corps or some globally known organization. But what we know from the evidence is that national or local staff often don't get evacuated in the same way. They don't have the same health insurance, the same salaries. And what we know from a targeting angle is that more often than not, the aid workers who are targeted with violence and war, they're local and national staff. And so, the next deeper dive to do in this project would be to disaggregate and really explore further really who's at risk. And when I think of the harms to the general civilian population, my mind often splits when I think I'm not even sure we can say all these humanitarians are in a category together themselves as against, and many people move between the realms. So there'll be a local civilian and then they'll go volunteer for an international aid organization in a camp and then go back. So there's more fluidity. And if you want to do that project, I would love to read it. I think it would be really valuable. And staying with student mode, let's say something about methods. I could just say what I found valuable in terms of the kinds of the reading I was doing, which might be helpful for any student. I found it really helpful to read a lot of ethnography and to read widely beyond. So the field of humanitarian studies is so rich. There's so much anthropology, and other disciplines that have contributed, and you will rarely see those texts in a law school. So you have to go to other disciplines. And I just think that's where we miss something unless we really start to engage outside. I was a bit lucky because my hat was originally a non-legal hat. So I had trouble thinking like a lawyer. I was like, I'm like a non-lawyer at heart. And so I think going to ethnography, and I honestly found reading beautifully written texts. And in the legal field, I was reading like Louis Slava and Sarah Newen, and I was thinking of the things they did with international law. And I think, maybe there's we can do this. We can have this kind of socio-legal approach. And I also found it really helpful to learn grounded theory as social scientists understand it. And so what that really taught me was how we can interview people without a causal hypothesis, but we can have like a foreshadowed problem. And then based on our interviews and our findings in the field, we can work backwards and code our findings to make normative claims. And so reading grounded theory and that kind of stuff helped me flip my brain to see how to take the field back to lawyers and say something. So I'll leave it there. Thank you, Dustin, for that question. And thank you so much for the conversation.
Really, really wonderful. Rebecca, congratulations on a tremendous book, but also I think a model of how to talk about a project. Really, really appreciate the thoughtful way that you've shared your work with us, many, many years of hard work, I know, but also the way that you're opening your project up as an inspiration to others to think about how to use some of your methods and the disposition with which you approach this project to think about new questions in IHL. We're really, really grateful and encourage everyone who doesn't have it already to use that code to buy your book. Thank you so much.
Thank you. Thanks, everyone.
Bye, everyone. Bye-bye.
Bye.